Okay, welcome to Criminal Justice Full Committee. It is Tuesday, March 5th, 2024. I'm glad you're here. For those of you in the audience who will be staying, we will get underway shortly. Madam Clerk, please take the roll.
Representatives Carringer, Davis, Doggett, Farmer, Fritz, Glenn, Hardaway, Howell, Johnson, Lamberth, Moody, Russell, Towns, Vice Chair Gillespie, Chairman Holsey. Mr. Chairman, you have a quorum.
Thank you so much. All right, from Tyler, sometimes called Solomon, we get our words of wisdom, sir.
Good afternoon, everyone. With March being Women's History Month, I'm going to go with the Queen of Rock and Roll, Tina Turner. I believe that if you'll just stand up and go, life will open up for you. Y'all have a great afternoon.
All right, I feel inspired. All right, any personal orders from anybody on the committee? All right, we will not waste time. By the way, we have item number 6 on your calendar. House Bill 1617 has been rolled 2 weeks. And item number 7, which is House Bill 1905, has been rolled 1 week. Which brings us to number 1 on the calendar, House Bill 2728 by Leader Faison. You are recognized, sir. You have a motion and a second.
Thank you, Mr. Chair and members. There was some questions that were brought in subcommittee. We do have an amendment that actually makes the bill that answers some of the questions in subcommittee. I have a drafting code 14565.
You said 1014565.
Yes, sir.
Is there a motion and a second? Motion and a second. We're voting on attaching amendment, whatever I just said, 14565. All those in favor say aye. All opposed, no. The amendment's on the bill, sir.
Thank you, Mr. Chair. Committee, it's very good to be with y'all today. I hope you're doing well, enjoying this beautiful weather. So a few years ago, a gentleman was at my church that had formerly been in trouble with the law, served time. He was on probation. And the Lord had worked in his heart. He was a truly rejuvenated man. He's still doing well. At that time during probation, he was fortunate enough to get a job. When you've served time behind bars and you have a felony on your record, people sometimes look at you a little differently. And so he was fortunate enough to get a job. His probation officer decided he needed to meet at 9 o'clock on Wednesday morning. It was a difficult situation for him. He couldn't drive, trying to navigate with a new boss. And so that began the thought process. Started talking to other people like Men of Valor. And in fact, it wasn't just a friend of mine, that they have people who are dealing with this same thing. So I came up with this notion that if you're in a situation like this and the judge thinks you are safe enough to meet on Zoom, that you can meet on Zoom instead of having to leave your work. And most people have a smartphone now that they can do that instead of having to leave work, possibly lose your job or trying to find a way there. Once you get out of prison, guys, I don't know if you've ever dealt with anybody, but navigating the ability to transition into life is phenomenally difficult. Paying all your fines, getting your license back, getting your life back in order after serving time is almost nigh to impossible. And this is just one way that I feel like we could potentially make it easier for people who are really got their best foot forward. And the leader just told me to renew my motion, but I don't think I can renew a motion because I don't have a motion in front of y'all. But if I was on this committee, I'd just call the question right now.
Yeah.
Yeah.
That sounded good. And it is sometimes a tedious process. It always took a lot of my time having to sign Hardaway's parole papers. So
Yeah.
I'm glad you've got this. Leader, go ahead.
Move previous question.
Hey.
Previous question been called. We are voting on House Bill 2728. All those in favor say aye. All opposed, no. Ayes have it. Moves on to government ops. Brings us up to House Bill 2099, which is number 2 on the calendar. Have a motion and a second. Oh, Representative Cochran is not in the house. We'll roll to the heel. That moves us to item number 3, which is House Bill 2279. Wait 1 second. Yes, sir.
May I go out of order just for a moment? I just noticed, and I should have done this. I see my public defender, Rebecca Lee, there. I just wanted to make her welcome to be here today. And I'm sorry, Mr. Chair, that I interrupted this committee, but she works hard at home and wanted to say hi.
Welcome. House Bill 2279 by Chairman Hawk. Is there a motion, a second? Chairman, you're recognized.
Thank you, Mr. Chairman and members. Had good discussion on this bill in subcommittee. Ultimately, House Bill 2279 will give a judge the authority to consider placing someone on the sexual offender registry if the victim is less than 4 years younger than the offender. I'll tell you what happened to create this legislation. A juvenile male, age 16, was charged with a sexual offense that would have been eligible for the registry. The victim was over 4 years younger than this individual, 11 years old, unfortunately. As part of the plea agreement, the registry was not required of the 16-year-old, and he was ordered to participate in a psychosexual evaluation and abide by recommendations. With only a few weeks left on his probation, there was another case that had been opened up that involved this same individual, the 16-year-old male, and this time a 12-year-old female who happened to be 3 years, 8 months, and 8 days younger than the individual. The judge in this case was wanting discretion to be able to place this individual as a juvenile on the confidential sexual offender registry, and this bill would allow the judge that discretion to do so, Chairman and members. I stand for questions and comments.
Okay, to get that done, that's in the amendment, I believe, that makes that bill, and we haven't put that on there yet. Am I correct in that? I'm showing 014385.
I'm sure you're correct, Chair. Forgive me, my documentation is not as updated as it should be, so I apologize.
It's a subcommittee amendment. Okay, all those in favor say aye. All opposed, no. Or it's attached now for sure.
Thank you. And I do recall, Chairman Doggett's not in the room, that the amendment to the legislation was an effective date that would go for, it would have a starting date for this. So it would not be retroactive. And forgive me, Chairman, that was Chairman Doggett's amendment, and I did not have that in my file.
That
So
is, you are exactly correct. Any questions for the sponsor of the bill? Yes, sir, Chairman.
I just had a quick question. What happens to the child once they reach age 18?
to the offender, if nothing else, in the way this was described last week, this is, as a juvenile, the registry is confidential. It is available to the court system only to know what is going on with the individual. If there is not an offense or not a reoffense by this individual, then they can petition to come off as they age, as they reach the age of majority. There was an age that was 25, I believe, they would stay on the registry, but could petition the courts at that point of turning 25 to remove their name off the registry. So I hope I got that right. I'm going to get a nod of the head from legal staff. So
Thank you.
thank you.
Any other questions? Questions on the bill? Question been called on the bill. We are voting on House Bill 2279. All those in favor say aye. All opposed, no. Ayes have it. Sir, it goes to calendar and rules.
Thank you, Chairman, members.
Let's back up and take item number 2, House Bill 2099 by Representative Cochran. You got a motion and a second. You're recognized, sir.
Thank you, Mr. Chairman, and I apologize for being a minute late. I had another bill going on simultaneously across the hall, so thank you for bearing with me. House Bill 2099 is brought to us by the District Attorneys Conference. And so basically we are, the General Assembly enacted the Fraud and Economic Crime Fund. And the intent behind that fund was stated to provide district attorneys general of this state the resources necessary to deal effectively with fraud, economic, and other crimes. So it was a special fund set up. It was set up, however, to be paid for through cases involving bad checks. And so there just aren't many checks written any longer. And so all this bill does is it allows a county to adopt a different way to collect that fee rather than the cases on bad checks. And again, it's permissive. The county can adopt it if they want to adopt it. And I will yield any questions.
Okay, Leader Lambert.
Thank you, Mr. Chairman. I'm just kind of curious, how'd your other bill turn out?
It turned out very well.
Well,
Yes.
1 out of 2 ain't bad.
No, that's right. I'll
But,
take that any day.
Hey, seriously, on this, I asked the question of some of the folks I know you've been working with on this, on why this would be needed, and you said a little bit of this a while ago. People just don't write checks like they used to. Thank God they don't write bad checks like they used to, but they don't write checks as much anymore. So it just kind of replaces that fund that used to be there for that. So it's a really good bill. I appreciate you bringing it, and I know this will help support law enforcement throughout the state. So, but that reduction in check writing apparently has kind of gone across the board. I still write checks. I have a check register. I still, balance my checkbook, but apparently we're a dying breed that does that. So thank you for bringing the bill.
Thank you.
Any other question for the sponsor? All right, seeing none, we're voting on House Bill 2099. All those in favor say aye. All opposed, no. Ayes have it, sir. It goes to finance.
Thank you, Chairman and Committee.
That brings us to item number 4, which is House Bill 1817. By Chairman Littleton, you have a motion and a second. You are recognized.
Thank you, Mr. Chairman. And this does have an amendment, but it's following the
We-
bill, right?
We do have an amendment.
14635.
That's what I'm showing too. You have a motion and a second on amendment. We're voting to attach 014635. All those in favor say aye. All opposed, no. Amendments on the bill, please proceed.
This bill, as amended, enhances from a Class D felony to a Class B felony the penalty for a person who negligently, by act of omission, engages in conduct that places a child 8 years of age or less in imminent danger or death, bodily injury, or physical or mental impairment.
Any questions for the sponsor? Yes, sir. Representative Gwen.
Thank you, Mr. Chairman, and thank you, sponsor. Why 8 years old? Why not older than 8?
Because that's the age of a child. And we just went with that.
The age of, I'm sorry,
Go ahead.
the age of,
We call that the age of a child. Like if it's rape of a child, then we call that 8 and under. We raised that from 3 to 8. I wouldn't mind it being all the way to 17, but that's, the fiscal note gets higher and
okay, thank you.
Leader.
If I may, just, again, that's normally where there's an enhancement break, and it's actually a question I've asked before as well on, okay, why 8? And it has been that way in the statute for a long time. And so that is where the kind of the mark is for enhancements in a lot of other bills. And it seems to be that is where, Chairman, I join your enthusiasm for having this go for all children. I mean, this particular bill, but 8 and under is a good place to start. So thank you.
Go ahead.
And again, we started with the aggravated rape of a child with that age, and it was 3, and several years ago, we changed it to 8. So maybe next year we can change it to 12, because I wouldn't have a problem with that either, but that's.
Your bill says knowingly. If a single parent's drunk inside the house and passed out, and their 7-year-old goes at the front door and gets in the street, doesn't get hit, but could have, this bill wouldn't apply to them. Knowingly. Okay. Yes.
Thank you, Mr. Chairman. This bill came to me, I had this drafted because of the drugs being inside the home and the children getting the drugs and are either passing out and they're giving them Narcan or they pass away. If you'll remember a few months ago, there was a 23-month-old little boy that got his dad's fentanyl out of the trash can and he passed away. So this is for that. That's why I drafted this bill.
Any other question for the sponsor? Question's been called. We're voting on House Bill 1817. All those in favor say aye. All opposed, no. Ayes have it, passes on to calendar rules. Next is item number 5, House Bill 2168. You got a motion and a second. You're recognized.
Thank you, Mr. Chairman. This bill as amended specifies that an order of protection related to allegations of domestic abuse remains in effect during the appeal unless the order expires by operation of law.
We have an amendment on this bill, I believe.
We do. It's one, I thought it was on there. I apologize. 13676.
13676. Is there a motion and a second? Got a motion and a second on amendment. We're voting on amendment 013676. All those in favor say aye. All opposed, no. Ayes have it, it's on the bill. Anything further? Any questions for the sponsor? All right, we're voting on House Bill 1617. All those in favor say aye. All opposed, no. Ayes have it, goes to calendar and rules.
Thank you, Mr. Chairman and committee.
No. I made a mistake. I called the wrong House Bill number that's going to calendar rules. This one was House Bill 2168. Now, item 6 has been rolled. Item 7 has been rolled. That brings us to item number 8, which is House Bill 1977 by Representative Capley. You got a motion? You got a second? You're recognized, sir.
Thank you, Mr. Chairman. House Bill 1977 authorizes any law enforcement officer certified by the Post Commission rather than any full-time salaried police officer to detain a motor vehicle being operated on public roads, streets, highways, when the officer has a reasonable belief that the vehicle is in violation of tinted window laws. So essentially what you have right now is you have some officers that are full-time salary, some that are hourly. There's no parity in the law when it gets to court. Those officers that are full-time salary can pull someone over. Those that are hourly kind of gets in the weeds. So that's what the bill does, Mr. Chairman.
Any questions for the sponsor? Chairman.
Thank you, Mr. Chairman. Representative. If I hear you correctly, you're saying that there are full-time salaried officers, and then there's some departments that choose to pay their officers hourly, and that would create, excuse me, a discrepancy when it goes to court, especially if there was a stop made solely for the purpose of a window tint violation. And because of that, it could have that entire stop thrown out. Is that what I'm hearing you say?
Yes, sir.
Yes, sir, Mr. Chairman. That you explained it much better than I did.
And so with your bill, it would allow those officers, whether they're hourly or salary, to be able to effect that traffic stop and it not be thrown out in court. Is that correct?
Yes, sir.
Where did you come up with this idea, if you don't mind me asking?
This was not my idea, Mr. Chairman.
Surely there was an instance or something
Sure.
that has happened that,
Yes, sir.
Mr. Chairman, if I could phone a friend here and defer to the leader for comments, that would be my preference.
We don't have that kind of time, son. Leader Lambert.
Members, I think our good subcommittee chairman is having a little fun with Representative Capley. He's still a freshman, so that's totally allowed. I am a co-sponsor on this bill, and this actually is occurring in our district, unfortunately, where we have some attorneys who, on some DUI stops and certain drug offenses and everything else, where they have started filing motions where, because a person is salaried, not hourly, they're still post-certified law enforcement officers, but the language of the statute is very specific. And so this just allows for that to match up and for criminals not to go free because of some little technicality. I mean, look, those lawyers, you just never know what they're going to come up with, okay? So can I get an amen, Chairman Farmer? So that's where the bill comes from. And so Representative Capley, I won't let you sit out there and just kind of, suffer too awful long.
Chairman Doggett.
Thank you, Mr. Chairman. I will say Representative Capley and I, we share a county together. In one of these counties, we have numerous small towns that have police departments. And in a lot of these places, they do have part-time officers just because they cannot afford to have the full-time salaried positions. And so this is going to be a great help and get some clarification in the law because they are out there working diligently each day when they're on shift. And, it takes a lot of time when you end up going to court for a case and it gets thrown out. The stop is suppressed because there's a technicality in the law that should have been addressed many years ago. So great work, sir.
Representative Towns.
Mr. Chairman, all my chairman, I am so glad you all explained that because I'm sitting here trying to figure out what in the world is going on. It makes absolutely no sense at all. That your law officer part-time or your law officer full-time, and this is really, really happening. All right, thank you.
Any other question for the sponsor? We're voting on House Bill 1977. All those in favor say aye. All opposed, no. Ayes have it, sir. Runs on the calendar and rules.
Thank you, Mr. Chairman.
Brings us to item number 9 on the calendar, which is House Bill 1978. You got a motion and a second. You recognize, sir.
Thank you, Mr. Chairman. I'd like to request for this to be rolled 1 week. I've got some folks that want to come testify, and they're currently meeting with community leaders across the state right now on the issue, and they're not able to make it here today.
All right, House Bill 1978 is rolled 1 week. Brings us to item number 10, which is House Bill 1920 by Leader Lambert. You recognize. You got a motion and a second.
Thank you, Mr. Chairman, members of the committee. No amendments on this bill. It is what it is. I mean, it just allows for
Did I
the,
roll the wrong one?
Mr. Chairman, do you want me to pause? Everyone seems to be pointing at Representative Capley.
Yeah.
Have you not?
Almost got a pay raise.
Hey, there'll be no commandeer in this committee, let me tell you that. Do you have a comment, sir?
Yes, sir. Representative Johnson, I wanted to formally apologize to you and the committee for my comments last week. I was under the impression during the presentation of the bill that we just rolled that you were being cute. It was made known to me that you were actually asking questions and not being cute, and I responded in a poor manner to that. So I just wanted to formally apologize to you and the committee. That was not my intention, but that's kind of how it happened. So I just wanted to apologize to you. I hadn't got a chance to talk to you. So absolutely.
Okay, we're
Thank
back
y'all.
in session. Leader Lambert.
Mr. Chairman, for goodness sakes, I've never thought, well, anyways, that happened. So are we on my bill at this juncture, Mr. Chairman? I just was going to continue, but.
Go right ahead. You have a
Okay,
motion
thank
and
you.
a second.
Well, so look, this is a very simple bill, but it is one of those things that has come up in court. General Sessions judges don't have discretion to go from 0 to 100% on sentencing percentages. This just gives them the ability to be able to decide in their own court based on the crime before them after someone has been convicted and their history and everything else on what they feel like is the most appropriate percentage given their jail. And I mean, it could be 20%, it could be 90%. It's whatever the judge in that circumstance decides to put down, gives them full discretion. That's what the bill does, Mr. Chairman.
And I appreciate that. I did not know that till you brought that out. All these years, I had it all wrong, but I'm glad you ran that. Any question for the sponsor? We're voting on House Bill 1920. All those in favor say aye.
Aye.
All opposed, no. Ayes have it. Goes on to calendar and rules.
Same, Mr. Chairman, members of the committee.
Brings us to item number 11, which is House Bill 2696 by Chairman Doggett. You got a motion and a second. You recognize, sir.
Thank you, Mr. Chairman. I've got Amendment Code 12227.
Yes, you do. You have a motion and a second on the amendment. We're voting on Amendment 012227. All those in favor say aye. All opposed, no. Ayes have it. The amendment's on the bill. Please proceed.
Thank you, Mr. Chairman. Committee, we are streamlining, it's been a long day, streamlining the process for any violation of conditions of release by making that violation, a new Class A misdemeanor. It also permits officers to arrest an individual for violating a bond condition as a new criminal offense. And upon arrest of the new offense, this bill would also give the judge discretion to revoke the bond on the original offense.
All right, any questions for the sponsor? Representative Johnson.
Thank you, Mr. Chair. So if the person is supposed to be home at 7 and they get home at 7:02 because of traffic, does that become a misdemeanor offense because they were late? Because that's that's a violation of their parole technically.
Go ahead.
Did I say that right? Am I making sense?
If it's a condition of their release that they
Be on time.
that they be a certain place at a certain time, then I would make sure that I was at a certain place at a certain time. I'd leave 20 minutes early to make sure I got there.
But if it's getting off work, you can't necessarily get off work early.
Well, I would think that the judge would take into some considerations to give them some type of variance, but we're talking about people that have committed some pretty violent crimes that this would be applicable to. Currently under law, the only thing that you can arrest someone on a condition of violating the conditions of their release is domestic violence. So for instance, if a murderer was released on bail and they had conditions, there's no way to arrest them. You cannot arrest them. You can verify that they have the conditions of release, but you cannot arrest them or revoke their bail just based off of that if they were found to be in possession of a weapon or something like that.
I just feel like there's a broad spectrum of what could happen here. So that's just my concern, but thank you.
I think those are other things smaller things were technical violations based
Sure.
on a bill we passed about 3 years ago, I think.
That's correct.
Any other questions for the sponsor? Seeing none, we are voting on House Bill 2696. All those in favor say aye. All opposed, no. Ayes have it. Goes, if you want to be registered as a no, please see the clerk. Goes to Finance. Is that the end of the calendar? I believe that is the end of the calendar. Is there a motion to adjourn? We are adjourned. Thank you.